For pronouncement of judgment, item 28.
You have set aside the selection and directed the state government to proceed further in accordance with law by issuing a fresh advertisement.
Item 29.
We have upheld the decision of the learned tribunal to release the retirement benefits without any deduction there. The writ petition is dismissed.
Yes. Adjournment request, if any, from item number 1 to 8.
I have in one matter relating to Itanagar bench. Your lordship permitted filing of the petition here. Day before yesterday, I made a mention, but it was not listed because date is there. Can it be listed tomorrow, ma'am?
When we granted permission,
My lord, this week only, ma'am, last week, because the present bench cannot take up the matter. Tomorrow.
But in item number 1, my lord, the similar matter, almost identical matter is pending with the only Supreme Court. So, my lord, may I prefer that matter is still pending, my lord.
the concept of the parties have submitted that the issue raised in the state petition is pending consideration before the honorable apex court, and the decision is awaited. Therefore, matter may be adjourned. Which court? And the request of the concept of the parties, matter is adjourned. For the matter may be listed in the month of January
Right.
2020.
Same order may be first in item number 2, my lord.
May I please, lord? With the consent of order, said I beg to mention item number 5, lordship.
Item number
5, lordship. Lordship may post the matter after vacation, lordship. In this case, lordship,
PIL.
yes, lordship.
That is in
Lordship, we have received certain documents, lordship, through RTI. Lordship, the most of the documents are vernacular in the.
okay, the concept of the petitioner pays some more time to produce better particulars in support of the PIL petition. Just after 8 weeks.
From item number 9 to 18.
Your lordship, I have instructions to withdraw item number 12, your lordship.
Item number 12,
Lordship.
then concept of the petitioner had submitted that on instruction as sought permission from this court to withdraw this PIL petition. What's the PIL petition about?
They know the giving allocation of software.
This is withdraw.
From item number 19 to 27.
Wait, please, your lordship. I beg to mention item number 19 and 20. I'm appearing on behalf of Mr. D.K. Das. He is indisposed today. Matter may come up after vacation.
Prosecution. But internal investigation doesn't mean that's these are then they have now given further prosecution.
Yeah, what do you want?
After vacation, Mr. DK Das is
10 weeks at the request of land council for the appellant 10 weeks.
obliged. Well, with the consent of the other side, Malad, I beg to mention item number well, 26, Malad.
26.
26, Malad.
Yeah.
May it come up for the vacation, Malad.
Yeah.
May it come up for the vacation, Malad. I need to bring a map also, your lordship wanted, Malad.
We don't have any jurisdiction to, we can't sit there. Otherwise also, we don't find any merit in this challenge. Delimitation proceedings, the court can't go into sit over as a appellate authority over the.
No, Malad, our
Decision of
case,
the
Malad, is that Malad, the districts which, Malad, the areas which have been, Malad, transferred, Malad.
That is purely within the domain of the administrative authority.
Malad, that is
And the
totally,
State government, not in the domain of the court. The Supreme Court has already disapproved that.
Malad, no, Malad,
Many of the.
Malad, apart from the delimitation part, Malad, we are mainly concerned, Malad, with the transfer of the Malad, administrative Malad, districts, Malad, to the other district, Malad, where, Malad,
That
there
is
are-
purely an administrative action. It's
Malad,
not
the
a
reasons-
judicial action.
true, Malad, but the reasons they have cited,
Open,
Malad,
unless it is violative of any rules or suffered from violation.
Malad,
Can't,
the reasons they have cited, Malad, that's totally arbitrary, Malad. We'll do that. Lordship wanted a map of the areas, Malad, that I have to bring on that on record,
10
Malad.
weeks.
Obliged, Lordship.
May I please, your lordship, I beg to mention item number 22 on behalf of the appellant. My lord, in this matter, on last suggestion, lordship has directed the appellant number to file an additional affidavit.
So assess the component.
Absolutely, my lord.
Yes.
Everything is done. We are filing the affidavit today. Let this matter come immediately after vacation. I have taken the consent of my colleague.
Counsel for the appellant has submitted that as per the direction given by this court. The assessment of the compensation which is to be paid to the respondent is almost complete, and in relation to that, the appellants will file an additional affidavit by the next date of hearing. That's immediately after Puja vacation.
We are
22nd,
filing it today itself, my additional. I'm so obliged.
22:10. Any other request?
May I please, your lordships, my lord, the prior consent to the other side of beg to mention item number 21, my lord. My lord, in this matter, we have to file an additional affidavit, my lord, to the reply, my lord, that is filed by the respondents, my lord. I pray for some time, my lord. Matter may come up after the vacation.
12 P.M.
It's it is with regard to the something of their language. And it's not only people to come now, there was a direction by the here that now the collections of the concerned area will take eviction first. Against that, the rest of the now the status report, all these things which will be taken over by these to be.
I'm obliged, my lord.
May it please your lordship. Your lordship, I have a prayer for listing of this matter tomorrow, my lord.
What's the urgency?
My lord, I'm seeking protection from disposition of my property, my lord.
When the disposition of the
Actu-
property, it's a PA.
No, my lord. Actually, my lord, it is relating to bank matter, my lord.
Bank matter.
My lord, what has happened?
Bank matter today also, many of the bank
It's
matters are
little
listed.
different, my lord. The facts are little different, like,
Whatever the
Well-
facts may be, okay, wait for your turn. What would be the fate of these matters to be listed and then decide whether it is to be listed tomorrow or not? Wait for your turn.
May I please the lordships. This matter may kindly be listed to what is the variance then in spite of honorable court order, interim order, they again appointed one person and going to the appoint another person.
Where,
Or
on which post?
join the director of economic and statistics. Already interim order passed, your lordship.
The appointment that-
May kindly be listed tomorrow.
In violation of interim order, you have filed contempt petition.
No.
You have filed contempt petition or what?
Contemplation on the, just to inform the your lordship,
They are informed for that purpose why it is to be listed.
tomorrow may kindly be listed for orders or
Tomorrow,
again.
not tonight.
I-
After vacation,
My,
yes.
My respectful humble submission before your Lord.
Yes, after vacation.
After the-
No.
Yes.
May please,
Or
my lord, in item number 40, my lord, we have filed an additional affidavit today, my lord. Item number 40, my lord.
No, division.
I'm praying for my lord, bringing on record, my lord.
Already this story.
Yes, otherwise which instructions, Lord? I am for the respondent.
You have for,
I'm for the petitioner, my lord.
what happened in that tribunal?
Order has been passed. I have a copy of the order.
What they have done?
MA for stay vacation has been dismissed. Lord.
Stay petition has been dismissed.
Dismissed. MA for stay vacation
A vacation of that.
has been dismissed. First cause of action has arisen. Lord.
My lord, I have already filed, my lord, I may be allowed to bring it to the record, my lord, only that, my lord.
Adjourn.
My lord. Obliged.
Your Lordship make,
Lordship, he's praying for
You want this adjournment or?
No, my lord, I'm bringing on to the record, my lord, the affidavit filed, my lord.
Yes, okay, then no.
Only that.
Fine.
Lord,
Sir, we have already declined to grant permission, sir.
After vacation, we'll
After vacation, you can have your date of your choice.
the opening,
Yeah,
after the vacation opening.
after vacation, it will be listed, sir.
May I please note, my lord, the learned single is given a certain direction to comply with the order, which is time-bound program, my lord, against which we have filed appeal, my lord, seeking stay, my lord. But we appeal this matter can be taken up tomorrow, my lord. It's a service matter.
No, urgency. When the single judges pass the order.
But it was passed in the month of, my lord, July.
Now we are seeking.
No, my lord, we have
within
filed
our-
afterward, my
it will
lord,
be- no, sorry. No,
Lordship, it is for listing of a writ appeal tomorrow, Lordship.
what's the urgency, man?
Lordship, this is for the arbitral tribunal. We have challenged the appointment of arbitral tribunal in the writ petition, which has been dismissed. And the
When the petition was dismissed.
Lordship, it was dismissed on 22nd August, but we have received the copy on 7th September, Lordship.
No urgency after vacation. Yes.
Very good.
Daily list for orders, item 3.
May I please, Your Honor. Lordship, as per the last order, the respondent was supposed to bring the status of the creation
Whether
of
the website
MIS.
portal is operative or not.
Yes,
Yeah, what happened? The portal,
the respondent was supposed to bring it.
No, not Dilip Mujum. Rajesh Mujum. So,
also for the timing.
she.
Yes,
Kindly pass over the matter for the time being.
Item number 4.
you have not taken steps which for the. Which for the applicant.
No.
Despite time granted on 22nd of July 2024, no fresh steps for service upon the notice. For service upon the service of notice upon respondent number 12 and 13 has been taken. Last opportunity of 3 weeks is granted to do the needful.
Item 6 for admission.
My lord,
We allowed it.
This along with the item number.
30. The liquidation was not. And it is not.
Well, at item number 30, we have prepared a review.
That we have already asked for.
That is what.
Yeah,
Well,
what's the, why review?
well, at review the,
At present, who is managing the affairs there?
they are managing. I have come from this.
They are managing.
Yeah,
Board of-
I have come
Board of
from,
Major Port Authority.
yes, I have prepared an appeal. My lord, I have kindly submit, let me submit. My lord, they have prepared an appeal. So my lord, my humble prayer is that in this matter, both the matters, my lord, senior counsel Surajit Datta has been engaged. He's today out of session. So my lord, 24th of October, can it be, my lord?
Whatever it may be, ultimately. Why review?
Review,
What's the problem in that?
review,
Even though it
review,
review
my lord.
facts which are relevant,
Yes,
but ultimately at present, they are the persons who has to, whatever the relief is to be granted to them is to be granted by them.
my lord,
What's the problem?
yes, my lord, that your lordship is correct, my lord. Your lordship is correct.
Then why you have filed this review petition?
review,
That's
my
why
lord.
we are asking for.
My lord, not, my ground is that no notice was issued. That is what we have could not produce the facts. And in the writ petition,
Okay, then now we have considered the facts, how it make a difference.
yes, my lord, the review, my lord, in the writ petition, the CIWT, Inland Water Transport Authority, they have contested, they have never hesitated or raised any questions that they are everybody.
Certainly, whatever their stand will treat, their stand as stand of this
Kolkata.
Appellate.
Board of Major Port Authority
Yes, appellate,
will take it as it is.
my lord.
But if now they are managing the affairs, they are that is the authority who has to comply with the order of the learned single judge. So it is not necessary
Yes.
for that reason.
Yes, if they assure that they will comply their order.
That is altogether different thing. Suppose tomorrow if we dismiss this appeal, then who is going to comply with this order?
My lord.
Who is going to comply with this order?
But because, my lord, the CWT,
Which authority would comply this order?
because they have, their contention is that they have taken entire, the assets.
Is it not true?
My lord, that is from this,
Is it not true?
we have not got any copy from the IA, or that is what contention was not known to us. Because notice was not issued.
Okay, contention was not known to us that at present who is managing this board?
That, my lord, I have come from the, my lord, the order, because we have not received the copy of that.
So what is your information?
My lord,
Who has taken over after this?
They have filed a contempt against
Dissolution
us.
of CIWTCL.
yes,
Who has taken over?
my lord, we have not received the copy, but they are IA.
Forget about copy and all.
Yes.
What is your information?
My information is that, my lord, the petitioners are not, review petitioners are not aware, because they are not aware whether they have taken and when they have taken. When they have taken, that is not the contention. The entire assets is lying here.
Fail to understand.
Right.
What's the problem if a person is coming and he is taking over the responsibility of whatever he has to do? What grievance do you have in it? This authority, this CIWTCL, this is already dissolved. It is no more in existence. From whom you get the relief?
My lord, that contention,
And if they are coming on
Well,
their own, that we are the persons, we are
Yes,
now
yes,
managing
yes,
the
Lordship,
affairs, what's the problem
because
with that?
our,
In fact, they are facilitating your interest.
yeah, since, my lord, we have not received the copy of the IA, these contentions we have not come through. What they have contented in IA.
Contempt, who has filed contempt?
They have filed
Yes,
contempt against us.
Against,
And including them as party?
Yes, sir.
Major court.
Yes, this road.
It's too much. You are asking, they have not complained, that they have not complied with the order and complaining that. And now you are challenging that they are not, they can't file an appeal against that order.
my lord.
Is that so?
And my lord, appeal may be heard on 24th. And let them furnish us a copy.
What about this review?
Review also on 24th, my lord, may dismiss the or allow, my lord.
Give me the details of that contempt petition.
Oh, my lord. They control the orders.
Managing Director, Major Mukherjee, Kolkata.
We are ready, respond number 2.
Kolkata.
Respondent number 2.
Okay. The review petition number 181 of the 2024 filed on behalf of the respondent number
Respondent number 1, 2, and 3.
respondent number 1, 2,
And 3.
respondent number 1, 2, 3 in writ appeal number
339 of
339 of the 2024 seeking review of the order dated
16/9/2024. Page 20.
16/9/2024
Page 24.
review order.
page 20. Passed in IA 2735/2024 in writ appeal number 2735/2024, whereby this court granted permission to the Board of Major Port Authority for Shama Prasad Mukherjee Court, Kolkata, to file an appeal against the judgment dated
25/4/2020. At page 30. 186.
judgment dated 25/4/2024, passed in writ petition number 6258/2016. This court has taken into consideration the fact that Central Inland Water Transport Corporation Limited is now taken over by the major port authority, Board of Major Port Authority. However, they were not made party in the writ petition number 6258/2016, and therefore it is necessary to this portal number. नहीं, इससे शुरू में
is now taken over by the Board of Major Authority. However, they were not made party in this.
however, they were not made party in the writ petition. Again, party in the writ petition, whereas the order dated 25/4/2024 is directly affecting the interests of it. Full stop. The review petition is filed by the
With petition.
respondent number 123 in writ appeal number 339/2024. seeking review of the order dated 16/9/2024 passed in IA number 2735/2024 on the ground that before granting permission to the major court authority to file an appeal against the order dated 25/4/2024 in writ petition number 6258/2016, no opportunity was granted to them. Full stop. Para. It is noticed that seeking compliance of the order dated 25/4/2024 in writ petition number 6258/2016, the respondent number 123 in writ appeal number 339/2024 has already filed a contempt petition before this court, contempt case number 494/2024, impleading the chairman and managing director of the major port authority, the board of major port authority, as one of the respondent. It is complained in the contempt petition, aforesaid contempt petition, that the board of major port authority is not complying with the order dated 25/4/2024 passed by the learned single judge in writ petition number 6258/2016. Full stop. Taking into consideration the above facts, we are of the view that there is no force in review petition number 181/2024 preferred on behalf of the respondent number 123 in writ appeal number 339/2024. Hence, this review petition is dismissed.
Correct.
Now come to this 339/2024.
My lord, I pray that the lordship may direct to file as a copy of the writ appeal.
Having heard the learned counsel for the parties and after taking into consideration the fact that the services of the respondent number 123 herein were terminated by the
What did it be? 1410
civil.
for central water, central inland water.
CIWTCL
Oh,
wide order dated
1410/2016.
14/10/2016 without there being any mention of the provisions of section 25F of the Industrial Disputes Act. We are of the view that matter requires consideration. Issue notice. Mr. Accept, Mr. Sonso, accept on notices on behalf of the respondent number 123. Let notices be issued to the respondent number 4 only. You are appealing. And Mr. Sonso, accept notice on behalf of the respondent number 4. Service is therefore complete. Copy of the writ appeal be supplied by the counsel for the appellant to the respective counsel for the respondents during the course of the day. Mr.
Yes.
Mr. Nath, raise some time to file counter
Yeah.
to the writ appeal. Time period for is granted. Just after puja vacation, in the meantime, effect and operation of the order dated 25/4/2024 passed by the learned single judge in writ petition number 6258/2016 shall remain stay.
Deeply blessed.
Okay.
Item 7.
Correction.
My lord, in another writ appeal, my lord, writ appeal 321 of 2024, there is already a direction to tag this matter along with that matter, my lord, because
Which matter?
writ appeal number 321
2024, my lord, because both writ appeal are arising out of same judgment. my lord.
That has been, notices have been issued in that.
No, my lord, that has been posted and after puja vacation, my lord, both the matters should be.
List along with writ appeal number so and so.
Much lord.
उसमें एक सेक्शन गवर्नमेंट में नंबर लेकिन अपॉइंटमेंट ऑर्डर के डायरेक्ट होते थे और अभी बोलते हैं कि इनको
Item 8,
May I please, Lordship? Lordship, the appellant, my lord, because the medical reason, my lord,
right in the central industrial
Yeah.
my lord, the appellant, because the medical reason, my lord, could not attend a single day duty. And thereafter, my lord, departmental proceeding was initiated and my lord,
You first of all satisfy regarding maintainability of the rate of this rate of appeal.
my lord,
Because prima facie we are of the view that the learned single judge, while exercising jurisdiction and exercising its power under Article 227 of the Constitution of India,
my lord,
not under Article 226.
my lord,
The tribunal is the authority which is regarded as a civil court having clothed with the power of a civil court.
Well-
Therefore, once the jurisdiction is exercised by this court by the learned single judge under Article 227, this writ appeal against.
my lord.
Not maintainable.
My lord, because my lord, the writ petition that we have filed attracting 227, no doubt, my lord, reason behind is that,
You
my
have
lord,
filed under Article 227.
no, 226, my lord.
Even though if you have mentioned this 226, as a matter of fact, the learned single judge exercises power under Article 227.
My lord, give me one opportunity about to address this issue, my lord.
Then the concept of the appellant pays for a granted time to satisfy this court regarding the maintainability of the this writ appeal. Because we are of the prima facie that the learned single judge by deciding while disposing of the writ petition number 2790 of the 2016 wide impugned judgment dated 25/7/2024 has exercised power under Article 226(7) of the Constitution of India. Just after 4 weeks.
My lord.
item 9,
Though the auction was challenged, it has been cancelled. It has been informed by my clients that it has been cancelled, but this matter has two facets, Lordship. Firstly, auction has been challenged and my illegal repossession of my vehicle. That prayer stays, Lordship. Therefore, I am only because without following anything of the Surface Act, my repossession has been done. Then
Without,
giving 13-2 or 13-4 notice.
before the DRT.
the matter is pending before the DRT and this is the order of the DRT, Your Honor.
Yeah.
This is the order of the Learned Judge Recovery Tribunal.
OA has been filed by them. I have received copies. Next date is
In the
25/10.
original applications, it is specific that the defendant is restrained. Restrained from to deal with the or disposing the security assets.
Yes, I will not do that. Lordship. Let them,
Thereafter,
let them
pending,
give, I am ready to regularize my account, Lordship.
Then approach the
Pending
bank,
attachment.
not to this court.
and thereafter my lord, one application was filed by the applicant bank before the Learned Judge Recovery Tribunal, and this is the application.
Whatever it
On which
is,
notice
you are
has
aggrieved
also
by
been
any
issued.
action of the bank authority, which is not in conformity with the provisions of the Securitization Act or rules, challenge it before the DRT. This court has no jurisdiction. The complete mechanism is given.
Lordship, what has happened? Now the DRT would also remain closed, firstly. Secondly,
Okay, this court is also remain closed for up to 20 years.
Same as
and,
High Court.
secondly, Lordship,
It is
to-
fixed on 24th.
25th, 25th.
Twenty-fifth. It is fixed on twenty-fifth in the
No,
CRT.
that is way for recovery of their dues.
In the OA itself, attachment is there.
File independent proceedings, if you are agreed by this, the action of the bank. It is not, we are not going to entertain such type of petition.
In the OA itself, this order is passed. Done.
Lordship, only thing now the auction has been cancelled. Only thing is, one that we regularize the account just because.
Can't issue such directions.
Lordship,
Can't
in,
force them. If
Lord-
there is any scheme applied to it, they'll consider it.
Lordship, in that, may I just, in the 2024 judgment, there is a small window of the, Wait.
Okay, give us, where is the
There is a-
2024 judgment? Three-bench judgment?
yes, yes.
Yeah, where is that small window? At least you should guide us, so we may also see out of that very small window, whatever it may be.
Lordship, otherwise it is. Understand? Yeah.
Original application has been filed, the account is NPA, it has been recalled.
Because after reading this judgment so many times, we have not found any window in it. Where is that window?
Yes, Lordship, para 29.
99.
Para 29, where does,
And along with that, para 30, you should also.
yes, that is there.
In one breath.
No, but,
Read.
yes. It could thus clearly be seen that the court has carved out certain exceptions when a petition under 226 of the Constitution could be entertained. In spite of ability of an alternative remedy, some of them, where the statutory authority has not acted in accordance with the provision of the enactment in question. It has acted in defiance of the fundamental principles of judicial procedure. It has resorted to invoke the provisions which are repealed where an order has been passed in total violation of the principle of natural justice.
Next.
It is, however, clarified that the High Court will not entertain a petition under Article 226 of the Constitution if any effective remedy is available to the aggrieved person or the statute under which the action is complained of has been taken. Itself contain a mechanism for redressal of the grievance.
Sir, so sir, in our opinion, you can't read this para number
29?
in isolation.
Yes,
It
yes.
has to be read with section,
Yes.
para 30. And para 30 is very clear, effective mechanism is there, then it can't be entertained. So
And the Lord,
mechanism is already there.
learned DRT has already exercised the.
What is it?
And just Lordship, we wanted to regularize our account, that's all.
Approach the bank, because we have not lended you the money. The bank has lended you the money. They are going to do that. They are the only person who can regularize your whatever the account and.
Then Lordship, we will withdraw it to approach the under section 17, Lordship.
To argue the matter for quite some time. And counsel for the petitioner wants to withdraw this petition with liberty to approach the debt recovery tribunal under the securitization. Dismiss with liberty as paid.
My presence will be recorded.
Item 10.
My presence will be recorded.
My lord, this is against the, my lord, appellate tribunal, my lord, order, my lord, phase 132, my lord.
The.
Delay has
they
not
have,
been-
refused to condone the delay.
Yes, yes.
What's wrong in that?
The wrong is that, my lord, merit of the matter has not been considered.
When, merits,
Merits of the matter, that's,
first of all, you have to satisfy regarding the limitation.
yes. Your lordship will kindly
Able to
see,
Satisfy the limitation.
first of all, your lordship will see page 124, my lord.
Yeah.
The settlement proposal we have submitted, bank has, my lord, yet to obtain the instruction, page 124.
Is there any settlement scheme is in vogue?
Yes, my lord, we have sought for
That is not
settlement.
there, not there.
There is,
No
there,
such settlement scheme is there. Where is
My
that
lord-
settlement scheme? Show us.
page 124, your lordship will kindly see,
What
the order sheet. We have been trying continuously, my lord. A retired professor, my lord,
You are trying continuously whether there is any such.
They have not
settlement
accepted.
Scheme is in vogue or not.
The scheme is there, but they have not.
That scheme,
Page 124, your lordship will kindly see
121.
124, my lord. Order sheet. Before the tribunal, appellate tribunal. Learned counsel for the respondent bank submit that a proposal for settlement. Till now, they have not disclosed, my lord.
The tribunal has also said if you are willing to pay, you could have deposited the money if the bank is not deposited. It can't even- Earlier. It's also a career. 16, 12, and we have the other repetition on, committee to file an appeal.
So where is that scheme, sir? Where is that scheme in?
Scheme, my lord, actually, there is a board approved policy, my lord.
Where is that? Black
is-
and white man.
That is there with the corporation, your lord.
Then that is there with the corporation and you have made a statement that is there. Where is that? You have to satisfy. Where is that scheme? And the DRT order is of 2018.
Yes, well, 18, then we came
And
to High Court.
still you are, the
No,
matter
madam.
is lingering on 2024.
No,
Ultimately, it's public money, sir. It's not.
no, we are ready to pay, my lord. Your lordship may record, we are
Ready
ready.
to pay, then pay.
But they are not accepting it, my lord.
No, that is their job.
That's why we
That is
came
not,
earlier
uh,
also.
That
in
is not
witness.
our concern.
The lordship kindly see,
In loan matters, nothing there.
only, my lord, your lordship will issue notice to them, let the delay
Why?
on the delay
We are
portion.
not satisfied even. Why should we issue notice, sir?
Lordship will kindly see the delay portion page 132, my lord.
Yes, read. And we
Second
don't
par-
find any illegality prima facie in the order of this tribunal. or
This was filed, my lord, in 2022, my lord. This,
22,
yes, my lord.
this appeal.
This appeal, my lord, before,
And this
Order-
appeal was filed, you approached this court in 2020.
approach in 20 years. Then COVID
December,
started,
in March 2020, court granted you stay.
yes,
Then in December 2021,
yes.
your writ petition was dismissed on the ground that you have alternate remedy,
Remedy.
file an appeal under section 20.
Yes, my lord.
Now you have filed this section 20 application. What's wrong in this order?
Now there is no remedy, my lord, after this, my lord.
No remedy, then if no remedy.
And we want to pay the money.
We can't create any remedy if there is no
Lordship
remedy.
will record that we want to pay
No-
the specified.
No remedy, therefore this 226. That question has also been answered by the Supreme Court in some of the judgments that.
My lord,
That if a person
After-
has not approached the appellate authority within prescribed time, then he can't come under Article 226 since there I am remediless, therefore this petition be allowed. No, can't be.
no, we, my lord, your lordship says tribunal also try to settle the matter, but the corporation, my lord, bank, they have not come up with any such sort of instruction.
What is the obligation on the corporation? Is
Corporation, my
there
lord,
any, show us if any person approaches for settlement, they are required to settle the matter. They have to, they are supposed to settle the matter on the basis of whatever their policy and,
Yes, yes, my lord. Their policy, we agree, my lord, but they are not coming up with any instruction. That is the why, my lord. The lordship kindly see the condonation application.
Recently, it doesn't get for that. You want to pay, you could have one of idea of now deposit. So now then you come up. with the provision to make that. To make it. Indeed. Then the-
And we have paid one upfront amount also, my lord.
15, 12 minutes. What I have those are.
anything else.
My lord, we have paid one upfront amount also on page 112. 1 lakh.
Whenever.
Before the tribunal, my
What is that amount against that?
They want to settle it, but
Yeah, you just show us. The DRT has passed the order when,
the was passed in 2018, my lord, August.
and you have challenged that
Yeah.
order before this court by way of writ petition
Yes.
when.
In February 2020, my lord.
So this order was passed in the year 2018, a specific month, 3/8/2018.
18, my lord.
And you have filed writ petition
In February 2020.
so it's almost 1.5 year.
Yes, my lord, 505 days, my lord.
Then your writ petition was disposed of when,
It was in, my lord, 21, my lord.
which date?
Date I have to say. Yes. It was disposed of, my lord, on, my lord, 16/12/2023.
Then you file an appeal before the DRT?
I filed it on 7th of June, my lord, immediately
9th of
after
June.
COVID.
9th of June.
9th,
9th of June.
yes, 9th of June 2020. COVID is, there is COVID.
Okay. COVID was there,
Yes.
fine. 2018 to 2020. What is the reason for filing, approaching this court?
That is,
Ignore
my lord,
this 2020 to 2021, ignore this period.
no, I have, my lord,
When your writ petition was pending, ignore that period.
yes.
What happened prior to that?
Prior to that, your lordship will kindly see page, your lordship will see page 71A.
71A.
Yes, we are trying to settle, my lord, by
Sir,
submit.
that can't be a ground. Then we
No,
they are
Hatko.
trying to settle and therefore we have not filed any appeal.
Corporation letter, my lord.
What do it mean?
The Hatco has submitted a letter to us, my lord. Your lordship will kindly see. It was on 21/10/2019,
Fine,
page 71A, my lord.
yes.
There, your lordship will kindly see that reference to your proposal for settlement of Hatco loan due at rupees 15,43,000 till DRT certificate amount.
That is of 21/10/2018.
No, page 71A, my lord, annexer
Yes,
F1.
21/10/2018. 2019.
Yes, yes.
That was also 1 year
No,
and 2 months after DRT order.
after 2019, after this, we came to High Court challenging this, man. That,
No more than it is another policy.
this is the, they are not accepting the money, that is why.
Yeah.
They are not accepting the money, so we challenge this order.
they're not accepting, then it's okay. Then allow them to take this mortgage property, that's all.
Mortgage property, well, agricultural land, only is 3 lakhs, we have stated, my lord. That's why, my lord.
That's all. That's all. Anything else?
If a lordship will issue notice, then they will come up, my lord.
We are not satisfied, what to issue notice?
My lord, the period
In
before,
loan matters, least interference.
my lord, the period from the date of DRT judgment to that settlement has been continuously effort has been made. Page 71A.
Okay, fine. Then carry on.
Now, only thing, my lord, if
Carry on, carry on.
lordship will dismiss this petition, the settlement that is pending now, as
Where
per
is
the,
that settlement?
as per the order of the DRT page 124, that will, they will not, my lord, give any, my lord,
24.
page 124, my lord,
Whose order is this?
page 124.
Heard learning concept for the list on for further hearing.
124.
124. Learning
Yes.
concept for the response submitted, the proposal was submitted by the applicant which is under consideration. But
They
list
have
on so and so and thereafter on.
Next page, your lord.
9/7/2024, this settlement or whatever it may be.
That is the impugn order, lordship. After that, they have not disclosed anything, my lord. So, the,
That is there. Pros the point.
now this, my lord, settlement can be arrived at now also, my lord, if your lordship.
Do it.
Yes.
We are not prohibiting either you or to the UDCO to not to arrive at a settlement.
Lordship
Carry
observe,
on your efforts.
that must if your lordship observe, because,
Nothing.
because this, my lord, will affect the settlement, my lord.
No, sir. Sorry. Click here. This writ petition is this writ petition is filed by the petitioner being agreed with the order dated 9/7/2024 passed by the Debt Recovery Appellate Tribunal at Kolkata in diary number 211/2022, whereby the application filed by the appellant by the petitioner under section 5 the Limitation Act, seeking condonation of delay in filing an appeal against the judgment and order dated the 31st of August 2018 passed by the Debt Recovery Tribunal in OA number 272 of 2014, whereby it has allowed the application filed on behalf of the Housing and Urban Development Corporation Limited under section 19 of the Recovery of Debts and Bankruptcy Act 1993 against the petitioner. Full stop. It is known as that the facts which are relevant for the purpose of adjudicating the dispute raised in the writ petition that the appellant, that the petitioners were advanced a house loan by the respondent UDCO in the year
2001. 2001.
in the year
2001.
in the year 2001. Full stop. The petitioners as appellants ne, full stop. Admittedly, the appellants have failed to make failed to pay the monthly installments as per the terms and condition of the loan agreement. And in that event, the UDCO was forced to approach the Debt Recovery Tribunal by moving an application under section 19 of the Act of 1993. Full stop. The said application was contested by the petitioners before the Debt Recovery Tribunal. However, the Debt Recovery Tribunal, while order dated 31st of August 2018, has allowed the application filed on behalf of the UDCO under section 19 of the Act of 1993 and directed
Page 7, please.
And issued a recovery certificate in favor of the HUDCO for a sum of rupees 15,43,876 along with the interest at the rate of 12% per annum till the realization of the said amount, of the aforesaid amount, would stop. Against the order dated 31st of August 2018, the appellant, that the petitioners have not preferred any appeal before the Draft Recovery Appellate Tribunal under section 130, under section 18,
Section 20, madam.
under section 20.
Yes, madam.
Sufficient.
Section 20 of
Has not provided any appeal under the provisions of the Securitization Act and instead preferred a writ petition before preferred writ petition number 1677/2020 before this court. Full stop.
Make 20% of the restaurant. Appeal to the.
1677/2020. This court by the order dated, the division, a coordinate bench of this court on 4/3/2020 has issued notices to the respondent, to the HUDCO and other respondents in that writ petition and passed an interim order in favor of the petitioners. Full stop. Ultimately, the above referred writ petition came to be dismissed by this court by order dated 16/12/2021 in view of the availability as not maintainable in view of the availability of remedy of appeal before the appellate authority under the appellate authority. Full stop. The after passing of the order dated 16/12/2021 in writ petition number 1677/2020, the petitioners kept quiet and ultimately filed an appeal before the appellate authority only on 9/6/2022. Full stop. Taking into consideration the above referred facts and circumstances of the case, the tribunal wide order dated 9/7/2024 has dismissed the application under application for condonation of delay preferred on behalf of the petitioners while observing as under para number 16. Having heard the learned counsel for the petitioners at length and after going through the material available on record, we don't find any illegality in the conclusion arrived at by the that recovery appellate tribunal in its order dated 9/7/2024. Hence, we don't find any case for interference. So,
Section 2.
that the Securitization Act of 1993. And this writ petition is dismissed.
Item 11.
Yes, sir.
Please, my lord. My lord, in this matter,
Yes.
a detailed report has been submitted giving the policy of the government by the concerned committee in the, about 12 days back, that is in last month, September 18th or 20th.
It is submitted before this court or it has to be
No, but it is submitted to the government.
Okay,
Only a detailed report has been given.
fine.
So it is now, since it has been submitted to the government, I'm also personally looking into it, my lord, so that if any inadequacies are still left over, we have not done it with reference only to the particular individual. We have taken into consideration various types of such employees which have got different nomenclature, though they are virtually doing the same thing. They join on temporary and they remain till the end. So to see that we come out with a particular solution, we have worked it out in a very detailed manner. Now the matter is pending before the government. Your lordship may give some small reasonable time. I will pursue it personally so that I'll then submit it to the court.
How much time?
Give it sometime next month, okay, towards the end or so.
The request of the learned advocate, list this matter up to 6 weeks. Yes.
I'm already.
Barometer 3.
I also want to point out, my lord.
Yeah.
One more fact. A similar, because that is not on record, but it should be brought to your lordship's notice. There was a similar case of contingent employee which came to the Supreme Court. So in that case, the court said, we will consider your policy, that's fine, but at least you take care of this particular petitioner. So we agree to that. And in the said order, they have said that the government is looking into the policy. They have recorded that fact. I'll place that order also before your lordship.
Next.
Very-
Item 3.
Yes, Mr.
My lord, I have given the instructions have come for me. Second paragraph, lordship, see.
How much time? Just give us the time and then place it before whatever the cabinet or whatever the authority concerned if you require to, you give us the timeline.
Lordship submitted on the second week of November, my lord. The proposal should
By
be
that
ready.
time you'll do
The proposal should be, my lord, we'll place it before the cabinet, my lord.
that. You should make this web portal operational, that's all. We are concerned with that.
My lord, and
You consider it various levels or whatever the levels you want to take into consideration or take it. Start this web portal operational, make this web portal operational, that's all. Our concern is this.
we'll make it, my lord, lordship will find from the instruction, we are trying to make it operational.
Why? Date, give us the date.
It was the end of November, my lord. We have to submit the proposal.
The end of.
November, my lord, we'll try.
Be
we'll have to-
reasonable, be reasonable.
My lord,
Please,
I-
be reasonable.
what I was saying is, my lord, we place it before, we complete our proposal part. Cabinet sits and we get
Be
it.
reasonable, sir.
Second week of November, my lord. If the holidays in
Date.
between.
You're recording your assurance and that's all. You do whatever at level you want to do it, give your assurance.
Falls from lordship, my lord, I'm in a safer position, my lord. My assurance without a
Then
written
we'll
instruction.
fix a date and then we'll not do it then. First choice is yours. Otherwise, we'll fix a date and then see, you'll be responsible for those consequences. Lordship has it on the 21st November. Last. Not more than that. I'll try and. So as a Majumdar, learned consequence. Respondent state has submitted that. Regarding the operationalization of the web portal. The matter is being considered by the cabinet meeting, in the cabinet meeting on 8/9/2023. And the Department of School Education has been advised to resubmit the proposal considering some aspects. It is stated that now the department is preparing the proposal for resubmission before the cabinet, covering all the aspects as instructed, so as to ensure operationalization of the comprehensive web portal facilities to all the concerned stakeholders. Stop. Mr. Majumdar has assured this court that the web portal shall be operationalized on or before 21st of November 2024. Yes.
Could it be all efforts should be made?
Right.
I assure.
Assurance. Assurance means assurance. Then face the court. By 21st of November 2024. But keeping in view of the assurance given by Mr. Majumdar, is this matter on 25th of November 2024.
Item 13.
The matter pertain to the implementation of Assamese language, my lord, and there are 2 acts are enforced, my lord. Several opportunities were given to the government, but none of them come forward, my lord, by filing any affidavit, my lord.
Yes.
Lordship may kindly share prayer, my lord, prayer number 4 in the PIL, my lord. Page 32.
Yeah.
A writ in the nature of mandamus should not be issued directing the state respondent to set up a separate directorate.
Para number 4 of
My lord, prayer.
Page 32. My lord, we have already implemented, my lord. Yes.
My lord,
Yes.
Sorry, my lord.
Para number 4.
my lord.
Direct to form a formal committee comprising of stakeholders of the present respondent, which may be headed by a retired judge of Tribunal High Court along with the other concerned person for proper and official language act 2020. Yes.
My lord, that is why, my lord, in the last occasion, my learned pen took time. That was pointed out, my lord, separate director is already there, my lord. What, my lord, prayed in the writ, my lord, petition.
So,
That
this
is why, my lord,
committee is already constituted.
yes, my lord, there is a separate director already.
Separate
Directorate.
directorate or committee.
Directing is still going to set up a separate directorate.
Mr. You are appealing for?
My lord, I'm in person, my lord. But so far, my lord, the last,
But last, on last occasion on 11/9/2024, this court has issued a direction.
yeah, day before yesterday, we have filed application, my lord, for implement.
Where is that?
My lord, that has not been the part of record, my lord. That may kindly be, lordship directed to call from, my lord. Next day.
Council, Mr. Chamaria petitioner in person has submitted that pursuant to the direction given by this court on 11/9/2024, an application, petition to increase director of official language implementation Assam is already moved. Stop. The same, how the same is not available on record. Registry is directed to list said application before this code along with this PIL number 23 of 2000, along with this PIL number on.
Right.
28th of October.
My lord. But the rest respondent required to file their affidavit, my lord.
If they are not willing to file, we can't force them.
Item 14.
Are you in receipt of all the documents?
Yes, my lord, I have received, my lord, I have gone through also.
Yeah.
But the situation is not very happy, my lord. Going by the documents, my lord, despite there is clear ban of holding lottery by,
That's why taking into consideration.
Yes, my
we have
lord.
Kept like this.
yes, state rules, my lord, in page 40.
Mr. Das, what we are expecting from you that if you are having some more material.
Yes,
this from before, so at least we can ask them specific reply from.
Yes, but just one aspect I'd like to place before your lordship, my lord. Festive season is coming. So
Yeah.
festive season is coming, my lord.
Yeah.
So I think, my lord, there should be some order from this honorable court restraining this type of activity. Some district commissioners have passed order. One of them I have, my lord. This is with regard to, my lord, Mankasar, South Salmara. Recently. Also will but it's not uniform everywhere, my lord. Some restraint direction to the state authorities.
This new. Direction says PNS.
This is basically, my lord, 144, earlier 144, 163 is it.
Lottery is a regulation. I think it will be-
One secretary for allegedly in the secretary for the.
Yes, Malord. This permission, whether these district commissioners are granting permission to organize the lottery or not?
In some cases, yes, in some cases, no, Milord. They are, as per the documents annexed in the PIL as well as one of the affidavit file, some of the persons, they are using government registered.
Which is that academic?
Yes, that affidavit will also will find. They have said that they have taken action against that person also.
Government registered DSB, BSNL.
Yes, yes, Milord. Page 63.
Yeah.
Yes. So they are using such.
Brother is having some information that the organizers of the lottery are moving application, are submitting applications before the district commissioner, concerned district commissioner. They will allow us to organize lottery and then they pass, don't do this, such type of orders, and they're taking it as a permission from the government.
Yes, Milord. Because look, these are not small exercise, Milord. These are huge exercise. So far as I also know, Milord. So without government permission, such events cannot be held, Milord. So some permission is there for from the deputy commissioner. And there is of the notification issued by the government of India. It is very specifically said that the state has to, ban any such activity, Milord.
This is such a
Act itself says in the notification in the PIL, your lordship will find page 40, serial number 22, that is 3 sub 22. Every
serial number
page 40, serial number 22, Milord.
40.
40, Milord. Yes,
Every
of the
state government shall have no
Yes.
lottery in any form organized other than the organizing state or is appointed distributor selling jurisdiction.
even under the act, state can do only upon fulfillment of certain conditions, Milord. Even state is also barred to some extent. So in that view of the matter, perhaps today one district commissioner has, Milord, passed an order, that order may come up before this court for challenge, or other district commissioners may not.
My lord, I have already received information from 25 district.
From?
All the district administration, they have replied, said they have not granted any permission. And 3 district, my lord, without permission, some person organized a lottery. After getting the information, we have lost and registered a case against them. One
Here the matter is this, some of the district commissioners have granted permission.
No, my lord, till there, I have received 25 district, but every district administrator said that they have not granted permission.
The 25, what about the remaining district?
Remaining, I'm getting information. My lord.
The payer petition is raising a important question, important issue regarding the organizing, illegal organization of offline and online activity in the various districts of state of Assam. Stop. Then it, Mr. Das, am I just curious? Has informed this court that as per the lottery regulation, as per the Lottery Impact Regulation Act 1998 and the lottery regulation rules 2010, only the state government can organize a lottery that too while complying certain, that too on certain terms. Would stop. It is submitted that in many of the cases, the concerned person moves an application seeking permission from the concerned district magistrate for organizing online or offline lottery, and the district commissioners and some district commissioners are granting those permissions without any authority to stop. And Mr. Das has submitted that since the present is a festive season and a strict prohibitory order is to be passed by this court so that the poor people of the state of Assam may not be duped by the organizers, organizers of the by the illegal organizers of offline and online lottery in the state of Assam. Stop. I mean, council, you are for state. I state for. And council for state has submitted that he is in receipt of response from 25 district commissioners concerned of the state of Assam. And all of them have been informed that no such permission has ever been granted by them to any person for organizing online and offline lotteries. It's called. It is noticed that till date, no response is filed on behalf of the state.
We have already 4 districts, they have filed.
4 districts, sir, we want a response of the state. not
State, yes.
individual concern. On the state to counter this PIL. Though some
counter affidavits as filed on behalf of the concerned district commissioners who have been implicated as party respondent in this PIL petition. Stop. We are of the view that the state government is required to file its response by way of counter affidavit in this PIL petition. That how the state government is proceeding to tackle the organization of illegal online and offline lotteries in the state of Assam. Stop. The respondent state is granted 6 weeks time to file counter to the petition. In the meantime, the state government shall issue necessary, shall issue direction to all the district commissioners, including the superintendent of police of the state of Assam, not to grant any permission to any individual for organizing online or offline lottery or lottery, and the concerned district commissioners and superintendent of police shall take immediate action against those persons who are organizing online or offline lotteries illegally. The said directions be issued by the said directions are required to be issued by the state government within a period of 1 week from today. Let's start.
Deeply obliged, highly obliged.
Yes.
Item 15.
It's the fight is not filed, no? Builder.
Not in this matter, my lord, I am appearing for respondent number 12, that is the builder.
Respondent number
12. Lord, we would like to file a reply. Very
I have already filed a affidavit of opposition, my lord. So for, now the land is allotted to whom?
My lord, actually, there is a suit pending before the learned.
No, it may be allotted to whom?
It was initially allotted to us, this, to the
Allotted
Santa, to the Santa.
This 15-year condition has been relaxed.
Yes, that's been relaxed by cabinet decision on 5th of July. And in fact, I was requesting your lordship, that
That
is
you
not been on
challenge.
record. Yes,
That you have challenged.
that is not brought on record yet. Though the affidavit is come by respondent number 5, but they have not brought that on record. They've only brought that 16 July 2022.
Government can reply.
My lord, your lordship may kindly see the affidavit in opposition filed by the deputy commissioner. My lord. Paragraph
Deputy
6.
Commissioner, why the deputy commissioner? Deputy commissioner is acting as per that government decision.
Yes,
It's the government decision.
My lord, humble submission before your lordship, my lord. Since, my lord, there is a private interest between the parties, between the petitioner and the,
You just show us, he has simply challenged that condition, that 15 years restriction. You have this sale for next 15 years, we have now relaxed that. Why? No, so bata hai.
my lord, for the
Whether
interest
you are
of
justified or not. We
My lord.
simply say this.
the petitioner and the respondent number 12. There is a quarrel between them, my lord, because,
Forget
my lord,
about that. Forget about that. He will just show us why you relax this condition. That is, if it is justified, it's okay. If
My
not
lord.
justified, we'll see to it.
that is
Why
just
you have relaxed that condition?
because
How
my,
that, it is not this deputy commissioner who has relaxed this condition.
after careful consideration by the cabinet, my lord,
What was the reason or what was the circumstances under which the cabinet was compelled to take this decision?
My-
Show us.
my lord. To that aspect, I will file an affidavit.
To that aspect, nahi hai, on every aspect you have to file an affidavit. To that aspect.
I have
nahi,
filed,
to
I have
that
filed,
aspect.
I have filed the affidavit, my lord. My lord, objection, the preliminary objection, my lord, because the same issues, my lord, there is
Really
a,
consider that.
My lord.
But you just give us the explanation that why the state government thought it fit to relax this condition. इतना सा बता दे
my lord. I will file an affidavit.
कि कौन सा पता है waste some time to file and counter affidavit to the government. What are the reasons compelled the state government to relax the condition of prohibition on the land sale for 15 years, which was allotted to
Respondent number 12.
Let's number, no, 9.
nine, respondent nine. Good stop. List on
Last week of November.
first week of November.
August.
Item 16.
This
My lord, at page 80, my lord, amended
Clause seven.
section 167. So, my lord,
on the last occasion,
in fact, my
the
lord,
matter was argued either in.
I think, my
petition
lord,
or
the
somewhere
state took time to
File response to
not
that
file,
and-
not, they said that I'll have the instruction and place it on the.
And they said, "Okay, we are not accept these two things.
Yes.
Mentioned in that.
Lordship will clarify that, my
This,
lord, other than that, they cannot insist.
This pollution certificate.
Pollution, fitness and all.
Yeah, they are granting that. Yes, madam. Who is appealing for this state now?
The central motor vehicle rules are challenged under challenge in this PI, my lord. So my senior is appealing for.
No, no, my lord, we are not challenging to that extent.
You file your response to that. No problem. But so far as regarding that at present that relevance is that despite specifically provided in clause 7 of rule 161.
Seven.
That in case where the challan is not satisfied, then only license to the offenders and registration of the motor vehicle as the case may be shall not be issued.
Yes.
So far as regarding pollution certificate, fitness certificate, there is no bar.
Yes.
But despite that, the state is not issuing that on the ground that challan has not been satisfied. And Mr. Seke on last occasion seeks for some time to clarify this position. What is it?
Lordship, current age against lakes, my lord. Lordship,
Pass over the time.
Item 17.
Yes. Yes.
Lordship, from the cause list, we have seen that all the respondents are duly served, Lordship.
So what do you want?
Lordship, I want your affidavit, Lordship.
Affidavit. Some of the affidavit has already been filed or not?
Already been filed in the, before the learned simple judge, Lordship.
They are not filing, then it's okay, not filed.
Then Lordship, after vacation, in admission here.
I mean, heard the concept of that. We are respecting that. Matter requires consideration, hence admit. No need to issue notice to the respondent says they are duly represented to advocates. Full stop. Just in due course for hearing.
Lordship.
Item 18.
My lord, it will be better for him to approach the apex court, my lord. Not yet receive any instruction from the apex court, even in the petition.
Approach this apex court.
No, we have not approached.
That is a problem.
Because in our-
Clarification from the Supreme Court, it would be very difficult for us to take a decision on.
But otherwise, my lord, it is difficult for the client also to approach the Supreme Court from there, my lord.
In fact, you are also aware that
And
the whatever the directions of Supreme Court are not very clear, and therefore we already moved an application.
And that is placed before the judicial side and not yet taking any decision. The letter which was sent by the Registry of Dishonorable Court on the forwarding the near court, my lord, order, that was placed before the apex court in the judicial side, my lord. Not yet take any action, they pass any order, my lord.
Was the next date?
Next days, my lord, that was, last date was, my lord, 5/8, and then no decision, my lord. Only simply, my lord, extended, the committee has been extended. That was the order. But regarding, my lord,
An application, though we are not here advisory jurisdiction. Move in simple application, I said, because The state has already sought clarification.
Because already a
This
severe,
is the situation we are facing, and now till that clarification. The other thing was that if the state or the high court would not have moved there, then it was okay, we could have taken decision, but once we have approached the appellate court to give us to clarify the situation. Now if we take any decision again,
Yes,
not
it will be contrary to them.
I have to take instruction, my lord, in that case. And because of all this confusion, they are languishing behind the jail, languishing in jail for last 8 months without,
yeah, right, we are also concerned.
Even
without
trial
any
was
decision
not
being taken
started.
where they have to file their bail application, my lord.
Yes, sir.
Already a search has been filed here.
Why some of the angry person can approach the Supreme Court?
I'll take instruction, my lord, from my client.
It's up to the Puja condition.
After this meeting.
Take note.
Supplementary list for orders item 31.
I'm extremely sorry, my lord. My instructions is that they don't want to, my lord.
Have you moved any application or simple?
My lord, I made a mention before your lordships.
Okay, let me, Mr. H.K. Thakur, concept of the appellate on instruction they submitted that the appellant does not want to pursue this. Writ of appeal and say, in view of the state appeal, this has not pressed.
Highly only.
Item 32.
Delay of 21 days and a notice has to go.
But say there's nothing in this matter.
Malo, on the,
Admittedly, the responsibility is senior to you.
no, not that, my lord, because when in the writ
Because your,
petition,
services of both the persons was confirmed on the same day.
same day, and no, my lord, the writ
He was
review
appointee of
petition was,
93 and you are appointee of 98.
but confirmation on the same date. My lord. On merit, my lord, I have not
And,
discussed.
On the almost identical posts.
Identical post, my lord, only, my lord, my issue is, my lord, he was promoted in the year 2018. Why he was promoted, he doesn't know, because no affidavit has been filed in the main writ petition. I was not heard. I was not heard, my lord.
Another bench.
Notice.
Another bench. Brother is having some difficulty. In earlier litigation, he appeared all of the part.
Item 33.
My lord, will it come tomorrow or after vacation?
Naturally, after vacation, he आएगा sir. How can he be tomorrow?
Wait, please, your lord. My lord, if your lordship would kindly come to the rules, my lord, at page 208.
Yes.
Selection, my lord, 2, somewhere in the middle, page 208. This is the relevant rules, my lord. Deputy Commissioner, Principal Secretary of Autonomous Council areas shall make the appointment of Gambura on the recommendation of a selection board constituted for this purpose by the Deputy Commissioner. 147, my lord, is the selection committee.
Yes,
My lord, the rule prescribes that
One-
select,
one,
page 208 is the rule, my lord. Election board, LEC, my lord, deputy commissioner, ADC revenue or SDO, circle officer. Now please come, and my lord, last subpara, the selection committee shall essentially assess the leadership qualities of the candidates along with his or her ability to inspire people and to lead a law-abiding and value-based life. So our challenge was amongst others on two grounds, my lord. Selection committee was not in accordance with the rule.
that,
And this particular, requirement, that there is a requirement of assessing the leadership quality, that was not shown, my lord. And page 147 is the select list. Sorry, selection committee, 147, my lord.
yes,
Kindly see, my lord, Debojani Chaudhary, ACS, ADC is there. Then, my lord, the number 4th column, Sanjeev, circle officer is there, that's Sanjeev Dole. And one, my lord, FAO is there, finance and accounts officer. DC is not there. So this is our case, my lord.
but you participated.
No, yes, I did, my lord.
Without raising.
No, my lord,
any
most,
objection. Even in the earlier litigation also, you have not.
no,
raised
my lord,
this
my
question.
humble submission is, no, lordship will take it appropriate viewing the matter, my lord, I am not there. That the person to be selected possesses leadership quality as prescribed by the rule. Where does it appear from the record, my lord?
So this, exactly this point was not raised before the learned people.
Yes, it was raised, my lord. It was raised. And learned single judge has dealt with it also, my lord. Please come to page 313.
Sir,
1 second, my lord. Yes. Para 10, my lord, page 313, last to 3 sentence. Challenge is based on the ground that advertisement is not in accordance with the prescription of the rule, namely so and so. Then my lord will kindly come to those were there, my lord, but it was one,
not even,
no, it was asked and it was pleaded also, my lord.
but sir, it was not argued.
But learned single judge has not taken note of, my lord.
Sir, this para number 5, your argument, this para number 5, your argument are there.
Yes, yes.
No such argument was there, sir.
No, kindly see, my lord, Mr. Chaudhary, so and so concerned, same has undergone so and so after amendment criteria, so and so it is submitted. Yes, it is submitted that leadership is one of the important aspect and the same was not taken into consideration. It is submitted that advertisement in question contains so and so. Then kindly see, my lord, last 4 sentence. It is also submitted that marking given in the selection, there was involvement of finance and accounts officer was not a part of the scheme. It is submitted
It was
mark
the main
granted.
ground that he was not initially as per the rules, the financial FAO, financial and account officer was not supposed to be in the selection committee, but he was included. This was the.
No, my lord,
This
our contention is very simple, my lord. The selection committee is in not accordance with the rules.
notice.
Yes.
Returnable on and so on.
Item 34.
My lord, fresh selection has not been made. So may I pray, my lord, status quo as on today be maintained?
Subject to.
Subject.
This is innocuous
My
order.
lord,
otherwise
will-
If you want, we'll pass this order.
subject to outcome, my lord. Any selection made would be
Any fresh selection made on the post of ground or what concern would remain subject to the decision of, subject to this writ petition.
deeply obliged.
What about this, award of the tender?
My lord, financial weeks were open and thereafter there was a status,
There is nothing,
no work order has not been allotted. My lord.
work order.
Financial bid was open, my lord, and thereafter there was an order passed by this honorable court directing status quo on the ground that they alleged that there was discrimination.
Discriminal non-responsive, they were legally.
Yes, yes. So thereafter, my lord, this impugn order, judgment and order before.
You are for,
We are on the document.
you are for department.
I'm for the department. Anyone has been
Who is appealing for the private? You are.
I was the petitioner for the honor.
Issue notice. Issue notice of, issue notice, so and so.
Good night.
IAP. Is there any IA?
No, my lord. In the main writ appeal itself, my lord, we made a prayer for IM interim.
Issue notice. Turn to accept notice on behalf of. Respondent.
Respondent number, my lord, I'm just. 4567. 4567.
4567.
Yes, madam is for 4567.
What about this,
I am for respondent
One-
for 1, 2 and 3 about.
you are for the respondent number
1, 2 and 3.
It's a firm to put in appearance, accept notice on behalf of the respondent number 1, 2, 3. So and so is appearing on behalf of the respondent number 4567. What about this others?
My lord, others 8 and 9 has to go register post, my lord.
Let notices be issued to the respondent number 8 and 9 only. True, registered AD and thus returnable 4 weeks.
But I have an interim prayer, my
I'm
lord.
opposing the interim,
But I'm-
lordship. I'm opposing the interim prayer, lordship.
We'll see to it, let us see.
The lordship, board issue in this case.
In the meantime, learned concept for the respective concept may file their counter to the writ appeal if they desire so. Matter on 28th of October. They are returnable on 28th of October, 28th of October 2024. In the meantime. Yeah, why you are opposing?
Your lordship, in
So
the,
if they are going to, then they have to take a decision. Your Lordship, may I just pray? Ultimately, then what would remain in this if the lender is decided?
No. It
Then
was not
what
like
would
that. Your
remain in this writ appeal, sir?
I'll humbly submit, Your Lordship, that my bid was declared to be non-workable on a ground which does not exist altogether.
That is the interpretation
Now-
that the learned single judges held,
Yes, Your Lordship.
and they are opposing to it. That no, there was a ground.
Your Lordship.
That condition was very much there. We have to decide whether the condition was there
Your
or not.
Lordship, the tender authority cannot impose any condition which is in the violation of the statutory authority. Now, Your Lordship, it was like that the tender work order should not be issued. So accordingly, the case was allowed, the petition was allowed, saying that the tendering authority will take a decision. Now, if Your Lordship says it, that the bid may be finalized and
Status quo. Status quo.
Your Lordship will pass one order in that case that the bid should not be finalized.
We simply say status quo as it exists today. Whatever happened, whatever not happened, that will remain as it is.
Your Lordship, if they say, come up and say that we have opened the bid and we have finalized, in that case, I'll be prejudicial.
How can it be when the learned single judge has already issued in direction? Either they will consider your bid along with his bid as treating it as responsive, or they'll grant him, but there is no question of granting him that now.
The status quo will be a protecting shield for both of us,
In the meantime, the respondent number 678, 4 to 8 are directed to maintain status quo as it exists today.
My lord.
Till next day, 4 to 7.
Highly urged.
Pass over Metro 16.
Mr. Zekia,
Lordship.
there remains is in respect of that this 167 subclause 7 says
Lordship.
that if this challan is not satisfied, then the offender, the application of offender for registration of renewal of whatever registration of the motor vehicle and this other things would not be are prohibited. But there is no question of this pollution certificate, fitness certificate.
Regarding there are three parts: permit, fitness, and taxes. These are the exceptions.
Yeah.
Yes, Lordship. So far as fitness is concerned, Pollution Control Board's certificate is a part of fitness. While giving the extension regarding the fitness, we have to look into pollution control. And there's a notification of the central government, Lordship, of 9th May.
Permit, fitness and taxes of the motor
Taxes.
vehicle.
So permit and taxes, we cannot restrain, Lordship. We have to give. Regarding fitness, to give a fitness certificate of a vehicle, the pollution control certificate is mandatory. There is a notification of the central government. Just now I have received, Lordship. There is a bar, Lordship, will kindly see, because the central government will be able to keep like the last point.
Space. 171.
Where there is a pending fine, then PUC certificate should not be issued. That is
So
in
far as
reference to the
regard-
central government.
So far as regarding permit and taxes.
Permit and taxes, I don't think we can restrain them, Lordship.
Don't think or you are
Lordship, that is why if individual case comes, this is a PIL. If individual case comes,
Simply say, yeah, that's this fitness certificate.
Lordship, we are
pollution
directed
certificates.
in total compliance of these provisions, we have to carry out our exercise. Then we are bound, Lordship. We cannot overdo anything, except this notification issued by central government referring to a Supreme Court judgment. So fitness will have some cloud.
Wherein?
এইটো কপিটো আছে নেকি আমাৰ তাত
Okay.
এইটো এটা ভাল হ'ল এতিয়া তুমি সফট কপি দেখাব পাৰা লাইসেন্স এইটো ইলেক্ট্ৰনিক ফৰ্ম এইখন এইটো NOC fitness tax. এখানে আছে, এখানে একটু। রঞ্জিত, এখনো তারিখ তো 17 ডিসেম্বর 18 এখন অলরেডি আছে এখনো কিন্তু কোয়া আছে যে এনওসি ফিটনেস নেই দিয়ে দিবে আগে তো কোয়া আছে
এখন সব
মানে এসব
कितने कम लोग हैं
এসওপি কোনো তো এখন রিপিটেশনে হয়
Mr. Chaudhary,
yes my lord
will clarify
yes
that except this, this so far as regarding fitness, if it includes PUC, then certainly this.
no my lord already there is an SOP was issued which were annexed at page 70. If your lordship would kindly come to page 71 my lord.
70.
A standard operating procedure for validation of driving license, etc., etc. Then if your lordship will kindly come to page 74.
Yeah.
Roman 6 was the bottom. If a challan is pending or has not been disposed of, then all transactions involving vehicle, that is NOC, fitness, tax, etc. and for driving license, that is renewal, address change are not permitted and are reflected to the traffic enforcement agencies across India. So, well, this is an executive instruction. How can it override the rules?
No, but this now 167 7
Yes.
says that accept these things, you will not accept application.
Other than two, my lord, they can do
permits, taxes of motor vehicle.
Yes.
Fitness is also there.
No, no, my lord. Page
and
80, my lord, except applications relating to permit fitness taxes.
Just a minute, if a challan is due beyond the period of time, except in cases of offences, prosecution by good, then application to receive license of as the case may be mentioned in the challan
shall not be processed.
Authority or registering authority, as the case may be.
Except application relating to permit fitness taxes.
So they can't, they can't refuse any application for permit, fitness and taxes on the ground that challan is pending. But here, now this latest, some circular of the government, 9th May 2014, 2024, which speaks about this, that in MC Mehta case, taking note of this, that some this pollution certificates are being issued in illegal manner or whatever.
Can I make one submission, my lord? Regarding this, lordship may keep the matter on reopening. Other two, lordship may clarify.
So Chaudhary, state is required to file its response to the petition. For that time period, for that time is granted. Full stop. Mr. Chaudhary has submitted that as per rule 167.
Sub-rule 7.
Just a minute, 167 of the Motor Vehicle Rules 1989 as amended. If a challan is due beyond the time period specified under the rules, the registration authority or the registering authority or the licensing authority are restrained from considering considering the applications with respect to the license of the offender or registration of the motor vehicle. But it is clarified that all the applications relating to permit, fitness and taxes of the motor vehicle are not liable to be are to be considered in accordance with law. Full stop. It is submitted that despite clear provision under subsection, under sub rule, under 167, rule 167, 7 of the rules of 1989, the registering authorities or the licensing authorities are not proceeding the applications filed by the offenders in relation to permit, fitness and taxes of the motor vehicle. Would stop. Mr. D. Sekia, learned Advocate General, has submitted that as per the mandate of Rule 167, 7, the licensing or the registration authority cannot refuse consideration of any application of an offender in relation to permit and taxes. However, it is submitted that in view of the latest circular of the Ministry of Road and Transport of Highways dated 9th of May 2024, PUC certificate cannot be granted for the vehicles with pending traffic fines. Full stop. He has submitted that otherwise, Mr. Sekia has submitted that so far as regarding his information is concerned, the applications in relation to permit or tax of motor vehicles filed by the offenders are duly considered by the licensing or registering authority. Full stop. Taking into consideration the above facts and circumstances of the case, we make it clear that in the cases of pending challans or traffic fines, the licensing or registering authorities are not are supposed to proceed the applications in relation to the permit and taxes of the motor vehicles and can't refuse to consider the same.
Well, I think one error has crept in, subject to correction, my lord. Fitness does not mean pollution, my lord. PUC is pollution under control. So regarding PUC, lordship is keeping in further hearing, but fitness has to be given. Fitness means, my lord, fitness certificate of the vehicle,
That is
commercial vehicle.
that is
That is interlinked, Lordship.
That is
The
it.
pollution and the fitness is interlinked.
Hey, or you may clarify that the fitness
But this order, this prima facie, my lord, this refers to PUC. That means pollution under control.
But sir, it appears that the fitness includes PUC.
No, my lord. Different. No, pollution control is something else. Fitness is, my lord, the motor vehicle inspector will inspect a vehicle and say whether it is
We'll consider it.
on next date.
We'll have to see the exhaust pipe,
List on.
whether the emission is within the permissible limit or not.
Let them,
give a-
if
Emission and fitness are two different
if
things.
we come to this conclusion.
We'll
that
file a
it
detailed
doesn't
affidavit.
Yes.
This fitness, then certainly will pass an order.
Lots will fix the matter after vacation, my lord.
Yes. List on, so after vacation. we'll do it.
We'll file a detailed affidavit, Lordship. Highly obliged.
29 October.
Deeply.
Subject to what my senior said. Lordship, there is a similar matter pending.
Yeah, there are 2-3 matters.
PIL 46 of 24.
It can be tagged together.
Two matters are there.
The DK Mishra.
One matter, they sought withdrawal with liberty to file fresh.
That is this one.
Achha, that is this. Okay. And another is by, I think so, learned senior counsel.
Mr. DK Mishra appeared, yes.
List along with so writ number.
So, next one.
Supplementary list, item 35.
Wait, please, your lordship. My lord, here we are challenging, my lord, the virus of the provision itself, as well as the consequential actions.
Delimitation.
Delimitation, my lord. Now, my lord, before I proceed further, please, huh? If your lordship would kindly come to page 195, my lord. Yes, 195. My lord, this shaded red portion is the missing autonomous council area. So, my lord, here it is contiguous. So their whole analogy of core, non-contiguous places being brought together. So, my lord, that doesn't arise. So it is contiguous. There is no scope of bringing those the analogy of core village, satellite village. These are all contiguous. Now, my lord, now if your lordship kindly comes to the rule position. Yes, my lord.
Is this the position after the difference of 20,001
Yes, yes.
Because now it
Yes,
also included ST. What does change from 6 to ST?
No, my lord, this portion is missing autonomous council itself.
This is the position under the original.
No, this amendment, yes, amendment came long back.
Once the original act was.
It was missing.
So whether that would also have this contiguous area within it, or this contiguous area comes after the.
It is from the very beginning, this is the position.
This red line is original.
Yes. Now, therefore, my lord, their whole analogy is wrong. Now, my lord will kindly come to the rule provision, my lord. If your lordship would kindly come to the amended rules at page number 107. Now, to enlarge the scope, my lord, these amendments were brought in. If your lordship would kindly have this, the preamble first. Whereas it is expedient to provide for the establishment of a missing autonomous council within the state of Assam with maximum autonomy within the framework of the constitution, comprising of the satellite area and core area for social, economic, educational, ethnic, cultural advancement of the missing and other scheduled tribe communities residing therein. Now, please come to, my lord, the queue. Satellite area means an area or area consisting of non-contiguous cluster of villages predominantly inhabited by scheduled tribe population having 50% and above as a whole in cluster and not necessarily in the individual village. So having regard to the map, my lord, I don't think this has any relevance. Core area means the compact and contiguous areas predominantly inhabited by scheduled tribe population having 50% and above as a whole in the area and not necessarily in the individual villages. Now, my lord, if your lordship would kindly come to page 108, 5.1, for the words tribal belonging to missing, the word scheduled tribe will be substituted. To this extent also we have no problem, my lord. Now, please come to the writ petition, my lord, paragraph, page 23. কোনটো stage ত দিছিল সেই order-টো? 135, né? 138. 138. আকৌ challenge টো কি হয়? No. The order to appeal 138 আছে, তারপর কি হয়? তারপর কি বললো? Milord, page 23, Milord. Now, these are the areas which are sought to be included, Milord. Kindly see. Yes. Now, for example, the first one, Sauldhua Bali, total population is 3516, ST population 190, ST percentage is. So this is not only missing, this is including Sonwal Kasari. Then Milord will kindly come to the next page. See, from my lord Berbhanga Gaon until the last, there is no village, Milord. In fact, in this whole place, the population is less than 50. Yes, yes. So, Milord, your lordship will find at page 24, none of the places have 50% or more tribal population. Not to speak of missing tribal.
You are talking about the villages,
Yes, which are sought to be included now, Milord.
but now they are included in that this satellite area,
Yes.
and that comes to 50%, more than 50%.
Then only, otherwise not. Now kindly see the place, villages, Milord, page 24. None of them, Milord. In page 24, none of the village. In page 25, only 4 villages.
Include all the villages, then
Milord,
if we include all these villages,
no, they
which
do
comes
not,
within the definition.
they
of
do not
satellite
meet
area.
those criteria of either satellite village or core village, Milord. They don't meet the criteria. My lord, I appreciate, my lord, there is a requirement of devolution of power.
Yes.
So, my lord, my humble submission is you have come out with a legislation. The
Essentially, you challenge this validity of this act itself.
And assuming, my lord, for the sake of argument, the act is valid, my lord, even then it does not meet the criteria.
First of all, because then there is no need of challenging the act.
No, my lord, question.
If that is so, then there is no need to challenge the act, sir.
No, my lord, what they have done, they have adopted the same principle in respect of
Now,
several.
different things, sir.
Yes.
Act is valid, but the provisions of the act has not been exercised in accordance with the whatever the criteria. And another is act itself is valid, therefore the consequential notification itself are valid. So particular, what is your precise
No, my lord,
challenge, sir?
our,
Either to the notification or the act.
no, all that we are saying is, my lord, the act also needs to be examined. And consequently, my lord, the end of the day, my lord, there cannot be a concept like satellite village. My lord, because my lord, once an area is declared to be a part of a autonomous council, the other people living in the area, my lord, they loses so many rights, my lord. So there has to be a balance. I don't discount the, the necessity of creating because of the peculiar problem of infiltration and all. It is there, my lord. But I think there are better ways and means of protecting the interest of the indigenous people.
What is your response?
My response is, my lord, the present delimitation exercise that has been undertaken is completely in terms of the 2005 amendment.
Which para you are referring?
My lord, my lord,
Which para of your affidavit?
my lord, today it has come for the first time, man.
First time.
Yes.
Then let them.
No, my lord, my humble submission is initially they fixed 30th of September, na? And now that they have deferred, my lord.
Deferred?
Objection hearing.
Objection hearing, my lord.
Draft only has been.
So कितने लगे delay को?
Time I would like to ask you.
Huh?
Like that one again.
1 month. On for interim orders, lordship can keep the matter after the vacation, my lord.
We'll consider.
In fact, my lord, already there was an interim order in the earlier proceedings that your lordships will get at page 130 capital A.
Earlier proceedings for what?
Yes, in 2005, when a similar exercise was sought to be undertaken, then we approached this honorable court. This was the order passed.
That was slightly.
Meanwhile, till 31/8, the same thing,
If
Milord.
they have already extended the period for this objection, then there is no
Then
question.
lordship will have it on the reopening day.
Yeah, for reopening day or whatever.
As far as my instruction goes, your lordship, they have made number of villages. So far as these revenue villages are concerned, only those parts were predominantly inhabited by the missing people, that will be included in the council.
How can it be, sir? How can it be? Only those part of that.
Only those part of revenue villages which are predominantly inhabited by missing tribe, your lordship, that part will be included. Ultimately, when final notification will be. When final.
You are for?
I am for the missing autonomous.
While you are responsible.
And my lord, there is one more thing. In earlier occasions, my lord, when this exercise was undertaken, it was done by the revenue authority. Now, this time, my lord, the exercise is undertaken by the missing.
There is another problem. In fact, in delimitation cases, so far as my knowledge.
Article 329, my lord.
My knowledge is concerned, the Supreme Court has stated that you can't.
329.
My lord, I have brought those judgments.
And
no, my lord, there are contra judgments also.
Because once this delimitation exercise in relation to the municipalities was challenged before the Rajasthan High Court.
In fact, my lord, Article 329, but there are judgments where Supreme Court subsequently has clarified, my lord. Anyway, lordship will, that's a larger debate. Lordship will.
Consider appearing for the state. And
my lord, can I make on prayer, my lord? Why not they listen to our objection and pass an order before proceeding further? I mean, the council people will.
That will be done. That is for your fixed for submission of objection. And
that you have already invited.
Yes, the objection was invited.
Okay.
They have submitted.
Okay, they will bring on record.
And Mr. And you are appearing for Mr.
My lord, I'm assisting.
So Dean Majumdar, I'm considering for the state, and Mr. Thakur, consider appearing for the missing autonomous conflict, there is some time to file counter to the petition. Time period for his practice list on 30th.
30th.
30th of October.
Next case. Well, item number next is same. you know.
Same.
My lord, on the returnable debt, lordship will consider the interim prayer. my lord.
We are here, sir. Really here. Yes, next.
Sometimes, my lord, when my junior colleague says something, I have to.
Yeah.
End of the day, my lord.
Who is your junior will take care of it. Thank you.
May I seek your lordship indulgence, my lord? May I seek your lordship's indulgence, my lord? My lord, I mentioned a matter in the morning, my lord, for listing. My lord, can it be listed tomorrow, my lord? I'm ready to take up a dismissal tomorrow, my lord. If your lordship pleases, my lord. Tomorrow, after going through the record, my lord.
We appreciate your courage despite that. Okay, tomorrow.
Yes, right.
Item 37.
The petitioner Salam said,
Sorry.
position लिखा है जरा नाम पे position लिखा है मतलब petitioner Salam the order dated मतलब 23/1/2024 passed in OA 37 of by
Some similar orders are
मतलब
there.
here
Give it.
little over. Alright.
A similar situation.
मतलब
And concept of the petitioner has submitted that. This for in red petition number 712 of 2024, involving identical issue, was pleased to issue notice to the respondent and also state the order passed by the learned armed forces tribunal regional bench Guwahati in that case as an interim measure. Full stop. Issue notice. Returnable. 8 weeks. Petitioner to consent for the petitioner to take steps for service on sole respondent by registered post with AD within a week from today. In the interim, the impugned order dated
मतलब 24/1/2000 23/1/2024 मतलब passed in OA
passing away
37
number
OA 37 of 2022
shall remain suspended till returnable date. हम पोस्ट ट्रिब्यूनल का लिख देना है कनेक्ट विद सो एंड सो ये इसमें और भी नंबर्स भी हैं उनके साथ में कनेक्ट सेम इशू इन द अदर मैटर
39 I can say मतलब
सेम yes
मतलब here मतलब the petitioner challenge the order dated page 28 मतलब judgment order dated 2/4/2024 passed in OA 12 of 2023
50% for life. Applicant, which would be stand round off for 50% for life. Uh,
Here our stand is same, malad, not aggravated and not malad, attributed to the military service, malad. In spite of that, the petitioner opposed that tribunal where after 14 years, malad. The tribunal whimsically passed the order without malad, considering our stand in the affidavit in opposition, malad. On the petitioner,
let us hear the issue notice. Issue notice on interim prayer of returnable of Where is the date?
Item 38.
May I please, Your Lordship? Lordship, here I am challenging the repudiation order, my lord. Basically, my insurance cover has been repudiated illegally, my lord. For that, the account has been got NPA.
Insurance cover?
My lord, my husband took a loan from the State Bank of India, and therefore I took my husband also took an insurance cover covering that loan, my lord.
Okay.
And that also after 1.5 years, he died, my lord. My husband died, and thereafter they have whenever I claimed the insurance cover covering that outstanding balance, outstanding loan, my lord, the insurance company has repudiated my claim, my lord.
That decision of the insurance company is under challenge here.
Yes, my lord.
Where is that?
Page 30, my lord. Yes. It is.
31st of July 2023.
My lord.
And the surface notice, how can you challenge both amended petition?
My lord.
This is misjoinder of causes.
My lord.
Both have the separate cause of actions.
My lord.
Yes.
But now the condition is that
Before against this order of 31st of July 2023.
Yes, my lord.
You have no other remedy?
My lord,
No other remedy?
my lord, no efficacious remedy, my lord.
How efficacious remedy? Which is that remedy you first show us?
My lord, rate is maintainable. My lord, I'll show your lordships. I would like to rely on authority, my lord, Honorable Supreme Court, my lord.
Yeah.
In that case, when insurance cover has been repudiated, my lord, rate is maintainable for against the state for claiming.
But this writ is against the SARFAESI.
No.
Yes,
My lord,
you have challenged that notice
against
also. How you can
no-
join both these causes?
my lord, I'm challenging basically the both, my lord.
Why? How can it be?
My lord, because of that insurance repudiation of insurance cover, my lord, the SARFAESI Act has come, my lord. Because if this my case
This
has not
cause
been,
of action arose to you way back in July 2023.
my lord,
You kept quiet.
no,
You
my
did not
lord,
challenge that
no, my
action.
lord. Thereafter, we made a representation before the authority, and the authority has replied.
Whatever it may be, authority of the insurance company.
Yes, and authority of the
What happened
bank
to
also,
that? What happened to that?
my lord.
What happened to that?
My lord, they have replied it. My lord will get their reply at page 41, my lord.
Yeah.
My lord, before repudiation, my lord, State Bank of India is the master policy holder. So they didn't go for it for the insurance cover. Before that, even before repudiation, they issued this section 13(2) notice, my lord. Because repudiation was on 31 July 2023.
That is altogether separate. This SBI Life and State Bank of India both are operating in different fields.
My lord, both SBI Life Insurance is a subsidiary company of the State Bank of India, my lord.
Can't be, you can't challenge both the, sir. What we are of the opinion that this petition suffers from misjoinder of causes. These are altogether two separate cause of action.
My lord, because of the repudiation, I do not have the option, my lord.
Whatever it may be, sir, you should have challenged this order before initiation of the securitization proceedings. You should have challenged this order.
My lord,
You kept quiet.
my lord, securitization proceeding was initiated before my repudiation. That is the difficulty here, my lord.
Sir, whatever it may be, these are the, or you satisfy us that in both the cause of actions, one writ petition is maintainable. We'll hear you. Satisfy us.
My lord, how it's maintainable, my lord? Because of that repudiation, that SARFAESI Act comes. Otherwise, my loan had been recovered, my lord. If they do not repudiate my claim,
that is altogether separate.
my lord, if they do not repudiate my claim, then definitely that will not.
Why you have not challenged that action of the respondents of the whereby your repudiation claim was rejected?
My lord, I have challenged.
Sir, you can't challenge it before the division bench. These are misgender of causes. You can't maintain both the cause of action in one writ petition altogether holding separate fields. That can't.
My lord.
Yes.
My lord, against the repudiation, lordship may permit me to approach before the learned single judge until that no coercive action may be.
Sorry. This can't be. You challenge, you avail your remedy before the debt recovery tribunal against this SARFAESI proceeding.
My lord, that will proceed, my lord. Till that at least, my lord. Because of that repudiation, I'm suffering, my lord.
Whatever it may be, sir.
And that repudiation is also
claim was legally rejected. File separate petition for that. And you, why you waited? This was rejected in July. Then again they have rejected your prayer in this March, November 2023. You waited for this proceeding.
No, my lord.
Initiated, and then you have come before.
I'm keep on approaching, my lord, the authority because the
keep on approaching for years. That doesn't mean that if cause of action arose to you, immediately you should have come before the court or whatever the authority concerned. You can't say, I have filed the representation years together and therefore now I'll approach. That is not.
My lord, my only submission is that I'm suffering because of that repudiation. Again, I'm returning my argument, my lord.
If your repudiation claim was illegally rejected, you have remedy to challenge it.
Yes.
You have not challenged it. You waited till these SARFAESI proceedings initiated and now you have challenged both the proceedings in one. That is not permissible.
And against the repudiation, my lord, writ petition is maintainable, my lord.
Repudiation, writ petition is maintainable not before the division bench, sir. Not before the division.
My lord, as it's a writ petition, my lord, the Honorable Supreme Court doesn't say anything about that, whether it's before division bench or single bench, my lord.
Ultimately, either of the party will lose the opportunity of further appeal. The question is this. If it, whatever the writ petition, if it goes against you, you can file a writ appeal. Against the bank, they can file a writ appeal.
My lord.
Why to deprive them from one opportunity?
My lord, we'll approach the learned single judge, my lord. Till then, my lord, no coercive action regarding that section 13(2), my lord.
That is not our policy. That we can't do. You approach the learned single judge, pray before the learned single judge, take part. Yes,
My lord. In that regard, my lord, why they have repudiated my claim? Because that I have suppressed the material facts that at the time of commencement of the insurance, I suffered so and so diseases. But
we are not on that.
my lord,
We are not on that.
my lord,
We are on the question of maintainability of the petition
my lord,
on two grounds.
yes,
First of all, so far as regarding subject to verification, against this repudiation claim also, you have an effective remedy to approach the ombudsman or some other provision under there. And apart from that, you have a remedy to file a writ petition or appropriate proceedings before this court. But now you can't club these two issues in one petition and then come before this court. That is not.
because I'm suffering from both the actions, my lord. Both are the impugn action, basically.
Whatever it is. So far
As
regarding
is
this
concerned,
SLC action is concerned, approach the DRT.
my lord.
And if it is permissible, take this ground before the DRT also that they have illegally rejected your repudiation claim or whatever it. If it is permissible, it is
My
always
lord.
open for.
As the surface matter is concerned, therefore, the matter has been listed before this division bench, my lord. Otherwise, it would have been listed before the learned single judge.
It would have been listed if you have only challenged that action of the rejection of repudiation claim. Otherwise, not. Yes. What to do?
My lord, I will withdraw, my lord. And liberty may be given, my lord.
After attempting to argue the matter for quite some time, and it concept of the petitioner submitted that he may be limit concept for the petitioner of inspection has submitted that he may be allowed to withdraw the select petition while keeping it open for the petitioner to challenge the action of the respondent SBI Life. What is SBI Life Insurance
Corporation Limited,
uh,
Company
Life
Limited.
Insurance Company Limited and the action of the State Bank of India through branch manager Silchar Bazaar branch of initiating surfacing proceedings. Availing appropriate granting SBLI of rejecting the repudiation claim of the petitioner as well as the action of the respondent SBI Bank of initiating proceedings against the petitioner under the SALFACI Act by availing appropriate remedy available to her under the law. Dismissed with liberty is great for.
Much obliged.
So lordship is correct, my lord, remedy is available before the DRT, my lord, under section 17 of SALFACI Act.
Item 40.
May it please your lordship. My lord, if your lordship would kindly come to order dated 6/9/24.
Yes.
My lord, when we move this petition, my lord, against the ad interim order.
Yes.
Then this, the matter was fixed on 2 days later. Therefore, my lord, this honorable court gave liberty to this CAT, my lord, to consider our MA, notwithstanding pendency,
Considered.
and subject to the outcome, we were given liberty to approach again. So, my lord, now what we have done, my lord, it's eventually it's an stay order. Now, if your lordship, what had happened, by on 1/10/2024, my lord, the order has been filed, whereby the miscellaneous application filed by BSNL to vacate the interim ad interim order has been rejected.
That is on 110.
1/10/24, my lord.
Where is that?
That we have brought on record, my lord, by filing the additional affidavit. My lord, before that, if your lordship kindly permits me to. Yes,
Sir, we just want to have a look at.
yes. May I read it, my lord? My lord, it's a very long order, but if your lordship would kindly come to page 220, my lord, 221. Sorry, 222. Now, what had happened initially, there was a posting order given, that order was recalled. Now there, my lord, I do not know where from this concept of retrospectivity has come in.
Retrospect.
Yes, my lord, please come to 222, para 11.
Yes.
We have re-examined the matter. It is a settled position of law that in the context of a right flowing under the relevant rule, which was sought to be altered with effect from an anterior date, and thereby taking away the benefit available under the rule in force at the time, such an amendment having retrospective operation, which has the effect of taking away a benefit already available to employee under the existing rule, is arbitrary, discriminatory.
Which is that rule?
And my lord will for a moment.
The policy transfer.
My lord, yes, my lord will kindly come to page number 85, my lord. This will clarify everything. No, first, my lord will kindly come to page number 82, 78. This is the rule, my lord. 78. Recruitment rules of BSNL Management Service, Telecom Operation Stream, MSRR Telecom 2023 in BSNL. Now, my lord will kindly come to page number 84. Now, the post in question is Chief General Manager. If your lordship, this is part of Schedule 1, please come to column number 7 towards the bottom. PGM means Principal General Manager.
Page 84.
Page 84, my lord. Column 7. Yes.
Yes.
PGM/CGM, so and so, so and so. Now, this is a post to be filled up by promotion by selection. Method of selection is selection. Now, kindly come to the last column. Executives in the senior general manager's grade with 3 years of regular service in the grade of GM as on 1st of January of the vacancy year. So these are the persons who are normally eligible. Now, please come to the note. This has got significance in this case. Selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority. So, my lord, apart from what has been prescribed, by an executive instruction also, it can be prescribed who all are the person whose case can be considered. Now, my lord will kindly come to next page. 6, note 6, last one.
Yes.
Now, I'll have your lordship's attention to 4th sentence from the bottom. This sentence starting with on the right hand side, CGM, PGM, has your lordship's got it, my lord? At page 85, 4th line from bottom.
They were recruited DOT CGM, PGM.
Yes,
Level 4.
CGM, PGM level post shall be filled up from regular ITS, HAG and HAG NF level ITS officers deployed in the BSNL who have entered 27th year of service as on 1st January of the year calculated from the year following the year of examination on the basis of which such officers has been recruited. Lord, my understanding is, subject to what losses may say, for promotional post, my lord, the officers who should be considered should be ITS, HAG and HAG non-functional level ITS officers. Now, the original applicant before the tribunal, my lord, he belongs to civil stream. He is not an ITS officer. So, my lord, who can hold this post? An ITS officer, that to an HAG one. Now, my lord, we'll kindly come to page number 177. This notification was issued for empanelment of officers. The recruitment rules of BSNL Management Service stream-wise 2023 have come into operation with effect from 31/12/22. BSNL MSRR Telecom Operation Stream under Schedule 1 provides that selection of officer for the post of CGM shall be made as per separate executive instructions to be issued with the approval of competent authority. That I have already read, my lord, at column number 7.
Yeah.
Accordingly, with the approval of the competent authority, criteria for empanelment of officers for holding the post of Chief General Manager in BSNL is prescribed as under. Kindly see, my lord, all serving absorbed BSNL recruited PGM grade officers, all serving ITS graded regular HAG level officer posted in BSNL, all serving senior general manager grade officers of BSNL for empanelment to the post of so-and-so. So, my lord, civil stream officer do not figure here. Despite this, my lord, what was done, this order was issued, my lord, at page number 182. In fact, there was an wrong assessment of the whole position, my lord. At page 182, on 7/6/24, an transfer and posting order was issued in respect of 9 officers. Here, my lord, serial number 6 is the applicant before the tribunal. Kindly see, my lord, he was Principal Chief Engineer Civil Chennai, Tamil Nadu Circle, and he was posted as CGM NE Circle, Dimapur. Now, this was taken exception by the authority. Please come to page 184.
Yeah.
DOT-wide ID note dated 26/24, my lord, this is an intra-departmental communication, has intimated that empanel process adopted by BSNL is inviolable for ITS cadre post being operated in BSNL as per cabinet approval and directed BSNL authority to comply with its instruction with immediate effect. In other words, what was conveyed was, my lord, ITS officers are the ones who are eligible to hold the post. This empanelment pursuant to which 7/6/24 order was issued is wrong. Now, therefore, it says, in pursuance to the above, officers mentioned in Annexure A who have joined as CGM after 26/24 are hereby relieved from the post of CGM with immediate effect and to join their duties as mentioned in the aforesaid Annexure A. So that 7/6 posting order was recalled. Now, if your lordship kindly.
Of all the,
No, yeah, it is all the officers. All the 9 officers. Page 185, my lord. Please see. Serial number 3 is the applicant before the tribunal. Now, present posting, CGM NE Circle. Now, he has been sent back to original place, that is Tamil Nadu. Charge of CGM 2 shall be looked after by CGM in addition to these existing duties without any extra remuneration until further orders. And then another officer is now holding the office. Now, my lord, will kindly come to page 188. Now, this is an communication by the BSNL headquarters to all telecom circles and administrative units. The guidelines for empanelment of officers for holding the post of Chief General Manager were notified with the approval of the Management Committee of the BSNL by order dated 24/23, the one which I read at first, my lord. Now they have given up this. Please come to 3, Roman 3:2. Existing panel of officers empaneled for holding the post of CGM in BSNL stands lapsed with immediate effect. Now, my lord, pursuant to this gentleman, he handed over charge at page 193. He suppresses this and moves the tribunal, my lord. And when we pointed out, tribunal does not take note of this, page 193. LEC, my lord, Sasikan, CJM, LEC relinquished officer Sasikan on 27/20/24. He having relinquished and in his place at page 124, my lord, 94, and another officer who was holding a charge of the another circle, my lord, he was given the charge, Sanjay Kumar. Now, my lord, in this scheme of things, where is the scope of retrospectivity, violation of rules and whatnot? It's a simple case, my lord. A panel was drawn erroneously. When it was pointed out, when it came to the notice, then they, my lord, reviewed their decision. Not only in respect of the applicant before the tribunal, out of the 9 officers, 2 did not join, 7 joined, and all of them have been sent back. So this is the case, my lord. This is a post which can be held by an ITS officer, that too at the level of HAG. And he's a person with engineering background, my lord, civil stream.
May I submit, Lord?
We'll hear you. We'll hear you without hearing me, Lord, we are not going to pass anything.
Now, having regard to this, now my lord will kindly come to the impugn order. I don't think, my lord, subject to correction for adjudication of these issues, all that has been referred to is really what is required, my lord. Now, please come to page 218, para 9.
Just
Yes. Vision order to go to this hatot, no? Page 115, my lord, of the writ petition.
30th of July.
Yes. The operative portion is at 117. In the meantime, we stay the operation of the impugn order dated 19/7/24 with regard to application, applicant only till the next date of hearing. Subsequently, it was extended. My lord, in one particular paragraph, we have summed up the entire case at page 201. In the additional affidavit which we have filed, my lord, we have summed up the entire substance substratum of the case. At para 5, the first sub-para. The petitioners has a lordship got it, my lord. Yes.
We'll just.
My lord. Content to the आपका can be okay. Take some cups of water. Review management. আর এটুক কি কোন আমার কোন কি বলতে টেলিকম টেলিকম সিভিল ম্যানেজমেন্ট সার্ভিস না
Yes, yes.
Yes, my lord. My lord,
201 you are referring.
yes, one paragraph, my lord, we have given the substratum of the entire controversy
201.
at page 201, my lord. Please come to the first subpara, my lord, of para 5. That the petitioners respectfully state that the learned tribunal misdirected itself in passing the impugn order, inasmuch as learned tribunal miserably failed to appreciate that process initiated pursuant to guideline dated 24/23 and 26/5/23 for empanelment of officers for holding the post of CJM in BSNL, which is a post in telecom stream, is in violation of the 2023 rules, while the respondent is an officer from civil stream and his service conditions are governed by civil stream rule 2023. While dismissing the MA, the learned tribunal erred in interpretation of the note under column 7 and note 6 under schedule 1, which is as per Union Cabinet decision dated 3/8/22. The content of the said note 6 is reiterated below. CGM, PGM level posts shall be filled up from regular ITS HAG, non-functional level ITS officers deployed in BSNL who have entered in 27th year of service as on 1st January of the year calculated from the year following the year of examination, on the basis of which such officers have been recruited by DOT. That any empanelment process for filling up the post of CGM under MSSR 2023 shall only be applicable to telecom stream officers, which include ITS officers absorbed in BSNL, and officers recruited directly in telecom stream by BSNL. It is humbly submitted that the learned tribunal heavily relied on the note under column 7 of the schedule 1 in isolation without applying the principles of harmonious construction, which resulted in an erroneous order. So, my lord, this is the controversy. Now, in this scheme of things, where is the scope of bringing in retrospective amendment, there was an order erroneously made. Lordship knows administrative authorities have power of review. If an order results in some erroneous thing, then my lord, authority can always, undo it.
Yes.
So therefore, my humble submission is, my lord, provisional order error. Please. No. Original stay order. Is it sure? Is 30. Initially stay little for tribunal. 1-1. 1-1-5. So therefore, my humble submission is, my lord, the original order dated 37/24 as well as 110 order should be stayed, my lord. Moreover, my lord, before coming to the tribunal, he has relinquished the charge.
Lordship, as on today, the order at page 209 of the affidavit which they have filed today, the order by which the MA for stay vacation has been set aside, that order is not under challenge. Although it may be they are pleading that it has merged, but it is not under challenge.
They may or they may not have challenged.
Yes, but
Earlier, they, by this order, they only maintained the interim order,
maintain the interim order.
refused to interfere in that order.
Yes. Now, Lordship, in this particular matter, no notice has been issued. We have not been served with a copy of the writ petition. I have appeared.
Please,
Lordship,
advocate, please, here these technicalities.
No,
these
Lordship,
are
I have
not been
I do not have a copy also.
Everything is clear here.
No, Lordship. On merit, Lordship, I do not have a copy. I am appearing only with a copy of the OA. I have come to know about this proceeding. I have come to know about this proceeding only in the tribunal, Lordship. Till today, notice was not issued. Copy of the OA is not served. A copy of the writ petition is not served. Today, I have received the copy of the affidavit. Only the affidavit.
The writ petition copy is not served. What do you mean by that?
Not served, no notice was issued, Lordship. In this particular matter, writ petition copy was also not served on us.
Okay, but you,
I have appeared only having coming to know of this proceeding before the tribunal, where they have submitted that decision is to be taken expeditiously.
do you have the copy of the OA?
I have a copy of the OA, Lord.
So, along with the copy of the OA, you have annexed this 20th of April 2023 order.
Yes.
This rules or whatever.
I will have difficulties with regard to the page number.
25. A5.
A5, yes. Here, eligibility criteria, all serving absorbed BSNL recruited PGM grade officers. I fall into that category. I am an absorbed BSNL. I am an absorbed employee, Lordship. I am an absorbed employee.
Absorbed BSNL recruited PG.
I am a PGM, Lordship.
PGM, you are
PGM.
PC.
That document we have filed in the rejoinder in the.
Sir, you are PC.
PC is a PGM post. It is a PGM.
CGM and PCM.
Yes.
is,
No. PGM is a PCE is a PGM post. That document is a part of our objection against their stay vacation before the tribunal. So the procedure should be followed, Lordship. They should provide me the writ petition. I will file reply. And if the stay is vacated, Lordship, he will have to go and join to the feeder post of PGM.
So you have already joined, sir.
Not joined, Lordship. We have
your post from Dimapur.
no, Lordship.
Dimapur relinquishing
In
order
terms
is
of
there now.
in terms of the order of the honorable tribunal, he has joined in his present post and he is working.
So another situation is there are two persons.
No, that person his name is mentioned, Sanjay Kumar, his thing is mentioned in the order of the relieving only. At A1, A2 only, it has been clearly mentioned. There is my relinquishment is immaterial. It is immaterial, Lordship. It has been
Ultimately,
and it is an additional charge. Additional charge given to that person only to look after.
ultimately, it's not that you were only the person who was singled out.
That was
This
not my case.
Whole list of 9.
No, that was not my case. My case was, Lordship, it is a promotional post. CGM is the highest post in a particular circle in the BSNL, Lordship. It is the highest post in the circle.
Yes, no order.
And in the Lordship rules, Lordship will see it is a promotion. CGM is promotion by selection. Procedure is provided note selection of officers for the post of CGM shall be made as per separate executive instruction. Executive instruction is my A5 in the OA. And I am a PGM level post, Lordship. That document is a part of record in the OA, Lordship. I have to file reply to the defect, Lordship. Today, Lordship, I am totally handicapped, Lordship, because writ petition is not there with me, Lordship. We have not been served with the writ petition. And Lordship, they have brought in this, in my humble submission, it is a fresh cause of action, Lordship.
Notice was not issued. Therefore,
Notice
there is
was
no
not-
question of giving notice. You have not filed on KVA.
No, Lordship, I am not blaming them, Lordship. I am not blaming them, but I am expressing my position, Lordship. I do not have a copy of writ petition. I am just aware of the facts in view of whatever proceedings going on in the tribunal. There are many other things, Lordship.
Notice. Just going to accept notice on behalf of the respondent of over. Copy of the writ petition along with the requisite document is supplied to him during the course of the day. Stop. He may file, the counsel for the respondent may file is a response to the writ petition by the next date of hearing. The prayer for interim relief would be considered on the next date of hearing. Let him.
Only thing is, my lord, they've instituted a contempt proceeding, that they will not proceed, my lord.
He is without salary since July, Lord.
Why you have initiated contempt proceedings?
Lordship, he
When
is,
you have already joined there.
yes.
Your
They have
superior is
relinquished
that
the
pursuant
charge.
to the stay order passed by this court. He has already joined there. There was the question of initiating.
He has submitted joining letter. He is going to the office regularly, but he is not given any duty. He's sitting idle. He's sitting idle.
Sit and enjoy the.
They are not paying salary also. They are not paying salary since July. Since July, they are not paying salary.
Salary and another thing.
Where he should go, Lordship? Now he is going to office
Okay,
regularly.
fine. Learn concept of the respondent may file the counter affidavit to the writ petition if he desires so by the next date of hearing. List on 25th of October 2024.
Yes.
Learned concept with the respondent assured this court that till next date of hearing, the contempt petition filed by the respondent before the tribunal, before the Central Administrative Tribunal, Guwahati, will not be pressed.
Deeply obliged.
Obliged, Lordship.
25.
Daily list for hearing, item 33.
Hearing.
Hearing. Hearing.
Yes, ma'am.
Hearing अब छुट्टियों के बाद करें. Hearing अब नहीं.
Rather, let it be in the second week. of
Remain in the
November.
list. Remain in the list.
No,
Well,
let
remain
it
in the list.
My lord, I would be out of station. And that's why this matter mechanic is second week
Whatever your convenient date.
in November, my lord, second week.
Just give him date, whatever is convenient.
Much.
Yes. On regular days, nobody is ready to come in the hearing cases, and today
Everybody has come.
That's enough. Just to test the patience of the court. Too much.
But